Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. All right, let's just belly flop right on into it, guys. Okay, so happy Friday evening, maybe wherever you are. I mean, for me, it's super late. This is totally a last minute decision to live stream this at this hour, but as soon as I saw the breaking news about the Petito family filing a complaint against the Laundrie family, and then as soon as I got my hands on the complaint, it's actually a relatively short one, a very short one, really, mostly factual allegations and things like that. I just decided I might as well just go ahead and talk about it so that everybody could see it with me and we can all kind of go over it together. So anyhow, really great to see a bunch of people here in the chat. Bunch of people. This is awesome. I know this is super last minute, like I said. So, alrighty, let's get into it, shall we? We're just going to pull this up. Not this. This. Okay, there we go. There we go. So here we have the complaint. And I will start off by saying that I have the complaint linked in the description below. And I have, oh, and by the way, before we get into it, I guess, a couple comments on the shirt. Hey guys. So the shirt is, this is for the 1992 Lithuanian basketball team. The first time that they were able to represent Lithuania as a free country after the fall of the Soviet Union. Today is March 11th, which is one of the two Lithuanian Independence Days. So to observe it today, I wanted to wear this fantastic, wonderful shirt, which represents freedom and everything that is awesome. So anyhow, I hope you guys are doing well. Okay, let's get into it. Alrighty. So here is the complaint. Now, for anyone that is maybe not so familiar with this case, this, of course, we are talking about Gabby Petito, the young woman who was a van life influencer who went missing. I think it was over the summer. I can't even remember the timing of this stuff anymore. She went missing. She was on a trip across America with her then fiance, Brian Laundrie. Turns out she died. And then we found out she was murdered. And then Brian Laundrie immediately returned home to Florida. He went to his parents. He kind of hid out with them for a while. And then he decided to get up and, I guess, go hiking, quote unquote. That was at least what they were saying, is that he just, decided to go for a walk, basically. Then he himself went missing. And then it turns out that he had died in the Florida Everglades. And there have always been some questions about his parents, what they knew, what they didn't know, what they were doing. So anyhow, so a lot of people have had a lot of questions about if there could be potential liability here. And people have talked about civil liability and criminal liability. So today we're only talking about civil liability. And this is by the parents of Gabby Petito, and they are suing the parents of Brian Laundrie. So basically we're going to go through here. And I have kind of scrolled through this, so I have an idea of what it is that they're alleging here, but I haven't gone into the details here. So there probably will be some things that'll jump out at me as kind of a first impression going through it. So, but I have, like I said, I have an inkling of what this is going to be saying. Now, we're going to be looking at it as any judge would be looking at any complaint. So, is this going to be a complaint that would, number one, survive? And number two, are these the kind of claims that maybe we could see somebody having a successful lawsuit over? So, those are kind of two different questions, right? Number one is, can this complaint survive the first step, which is a potential motion to dismiss or a demur? Now, the standard for that is very low. Remember, if you've been following the other lawsuits on this channel that we talk about, when we've gone through complaints, I just did a motion for summary judgment the other day, but I've done a number of complaints on this channel already. So generally speaking, what we're talking about is a very low standard. Most likely, you can have a complaint where somebody kind of just word vomits out a lot of facts and some general allegations. And if they happen to fit all of the boxes of the elements of a particular claim, then it's probably going to survive. Sometimes it's a little bit messy because you might go back and forth between the parties. It's always a lot better to have a clean complaint that is very clear. You know exactly what they're alleging, you know exactly where the facts fit into the different elements into those boxes. But you can still have one survive that is a little bit messier. I've seen it because I've seen complaints that were filed by prison inmates in the California prison system that had all kinds of gobbledygook that I literally had to cut apart a handwritten complaint, a copy of a handwritten complaint, and rearrange the pieces so that they all fit into a timeline so that I could then literally paste it together so that I could understand what they were saying and take a look at whether or not this was a complaint that could survive. And oftentimes those complaints would survive. So if those are the type of complaints that can survive, where somebody's just like kind of word vomiting onto a page, the likelihood that something is going to be struck down kind of low. So just to keep your expectations tempered as we go through. Because basically all you need to do is to state a plausible claim. Have you alleged enough facts? That's the basic question there, is have you alleged enough facts to state a claim that is plausible? It doesn't even necessarily need to be a widely recognized claim. It could be a new claim that is of a first impression technically, but it has to have some sort of basis, some sort of legal authority. Basically, it can't just be like, all of these things happened and I'm mad. So anyway, that's that's simplifying it quite a bit. But anyhow, I digress. Okay, let's go into it so that we can sort of compare how that sort of fits in this sort of situation. Okay, here's the complaint. You see that this has been filed in the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida. So this has been filed by Joseph Petito, Nicole Schmidt, by and through their undersigned counsel, and filed within the complaint against the defendants Christopher Laundrie and Roberta Laundrie, and in support thereof. So this is what they allege. They say that this is an action for damages that exceed $30,000 exclusive of prejudgment interest, costs, and attorney's fees. Now note, it says that it exceeds $30,000. So that doesn't mean that they are only going for $30,000. They're going for at least $30,000. And this is probably just, that number probably has something to do with which type of court that this would be eligible to fit into, right? Because you have some courts that are, or most all jurisdictions, I would say. I hate saying all because it always scares me, but more than likely, all jurisdictions have some kind of small claims court. In California, if I remember from studying for the bar exam, the limit is like $5,000 or something. But I did just watch a video of Uncivil Law and Attorney Tom going over Reddit memes, and they mentioned how I think in Texas it's like $20,000. So that $30,000 might just be the amount that is required in Florida to keep this complaint out of the small claims court, meaning that you have all kinds of rules on discovery and that kind of stuff. Anyhow, venues proper in Sarasota County. Okay, we can kind of skip over that a little bit because we're talking about how, all right, Joseph Petito's from Vero Beach, Florida, Nicole Schmidt's from Blue Point, New York, and then the Laundries are from North Point, Florida as well. Brian Laundrie and Gabrielle Petito became engaged to marry on or about July 2nd, 2020. On July 2nd, 2021, Brian Laundrie and Gabrielle Petito left New York in a van owned by Gabrielle Petito to take a trip to the Western United States, which was expected to last for several months. Prior to the trip taken by Gabrielle Petito and Brian Laundrie, Joseph Petito and Nicole Schmidt and Christopher Laundrie and Roberta Laundrie had a cordial relationship. Gabrielle Petito had hopes of becoming a travel influencer, a van lifer, and document her cross-country travels on social media sites such as YouTube, Instagram, and TikTok. During the course of the aforementioned trip, Gabrielle Petito called her family almost daily, including her parents, Joseph Petito and Nicole Schmidt, and her siblings. The last communication that Gabrielle Petito had with Joseph Petito was on August 21st, 2021. The last communication that Nicole Schmidt had with Gabrielle Petito was on August 27th, 2021. It is believed that on August 27th, 2021, Brian Laundrie murdered Gabrielle Petito. The cause of her death was blunt force injuries to the head and neck with manual strangulation. Ugh. This live stream is probably going to be demonetized now. That's fine. Whatever. Gabrielle Petito was 22 years of age at the time of her death. After Brian Laundrie murdered Gabrielle Petito, Brian Laundrie sent text messages back and forth between his cell phone and Gabrielle Petito's cell phone in an effort to hide the fact that she was deceased. On August 27th, 2021, it is believed that Brian Laundrie sent a text to Nicole Schmidt in which he referred to Gabrielle Petito's grandfather, Stan, by name. Gabrielle Petito never called her grandfather by his name. And I know that that was something that was talked about quite a bit when people were trying to figure out what had happened in this. You know, obviously this was like a nationwide developing story back in, I guess, yeah, it was back in really September. It is believed and therefore averred that on or about August 28th, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, that he had murdered Gabrielle Petito. Okay. On that same date, Christopher Laundrie and Roberta Laundrie spoke with attorney Steve Bertolino and sent him a retainer on September 2nd, 2021. Okay. So it's interesting. I'm curious to know how they know that, or what makes them think that Brian Laundrie told his parents on August 28th that he had murdered her. They don't need to show that. They don't need to go into that level of detail in this complaint, but I'm just personally curious. On August 30th, 2021, Brian Laundrie sent a text message from Gabrielle Petito's cell phone to Nicole Schmidt stating that there was no service in Yosemite Park in an effort to deceive Nicole Schmidt into believing that Gabrielle Petito was still alive. On September 1st, 2021, Brian Laundrie returned to the home of his parents, Christopher Laundrie and Roberta Laundrie, driving Gabrielle Petito's van. Interesting. So interesting that Christopher Laundrie, so kind of looking back on the timeline. So on September 2nd, they had sent a retainer to the new attorney. But back on the 28th, they had already spoken with attorney Steve Bertolino. Interesting. Okay. So moving back down to where I was before. At this point in time, so back to September 1st, there was no contact between Joseph Petito and Nicole Schmidt on the one hand, and Christopher Laundrie and Roberta on the other. From August 27th, 2021 until September 19th, 2021, when Gabrielle Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabrielle Petito. While Gabrielle Petito's family was suffering, the Laundrie family went on vacation to Fort DeSoto Park on September 6th through the 7th, 2021. In an effort to avoid any contact with Nicole Schmidt on or about September 10th, 2021, Roberta Laundrie blocked Nicole Schmidt on her cellular phone such that neither phone calls nor texts could be delivered, and she blocked her on Facebook. On September 14th, 2021, with full knowledge that Gabrielle Petito had been murdered by their son, Christopher Laundrie and Roberta Laundrie, through their lawyer, issued the following statement. Quote, "It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family," unquote. On September 16th, 2021, attorney Richard Safford, on behalf of Gabrielle Petito's family, issued a letter to Christopher Laundrie and Roberta Laundrie as follows. Okay, and this is multiple paragraphs for anybody that's listening on the podcast version. "We are writing this letter to ask you to help find our beautiful daughter. We understand you are going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen." End quote. Despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito and Nicole Schmidt or law enforcement. So far as I'm reading this, my first thought is if they have I I don't know. I just my first thought is that my advice would be to not talk to the media, not talk to law enforcement. So if there is any information that Brian Laundrie did give his parents in that time, it is not privileged, but I don't think they're under any kind of a duty to provide that information. Because also at the same time, that would incriminate their son. If they happen to know where her remains are, there's only one way that they would know where her remains are, because they weren't there when it happened, right? Anyhow, so the thought that's kind of bubbling up is under what duty, what responsibility did they have to give information when they weren't the ones that were there when things happened? Okay, back to the complaint. Christopher Laundrie and Roberta Laundrie instructed that all contacts were to be made through their attorney, Stephen Berlino, and he issued no comment when asked about Gabrielle Petito's well-being. So the fact that they said that they weren't talking to anybody unless they were talking through their attorney, yes, that's appropriate. That's fine. I see nothing wrong with that so far. While Joseph Petito and Nicole Schmidt were desperately searching for information concerning their daughter, Christopher Laundrie and Roberta Laundrie were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. Okay, so that's maybe not so good, because although in the conversations that we were having around this time, he wasn't under any requirement to stay in the country. Because remember, he was if I remember correctly, he was a person of interest, but that was it. I don't believe that there is any sort of an obligation for someone who is a person of interest to stay within a certain jurisdiction. Okay. Back to the complaint again. Christopher Laundrie and Roberta Laundrie knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt and knew that they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well being and the location of the remains of Gabrielle Petito, yet they repeatedly refused to do so. So, okay, so what? So they knew that they could, but they didn't. In doing so, Christopher Laundrie and Roberta Laundrie acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. But the question is, what are those rights? What are they alleging that those rights are? So I've already got some questions here that are not being answered so far, but we'll continue because maybe they'll be answered as we go on. And I do see in the chat that people are saying, what about a moral obligation? That's the thing, is that what we're talking about here is a civil lawsuit, and morality and law oftentimes they do have a uh, an overlap between the two, right? But that's not always the case. Christopher Laundrie and Roberta Laundrie exhibited extreme and outrageous conduct, which constitutes behavior under the circumstances, which goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. So, what the allegations, like, they haven't exactly come out and said it, but this is starting to sound like an intentional infliction of emotional distress claim. So I'm going to finish this because we're almost to the end of it, and then I'm going to go into the elements of intentional infliction of emotional distress and that kind of stuff. So, okay. Um as a direct and proximate result of the willfulness and maliciousness of Christopher Laundrie and Roberta Laundrie, Joseph Petito and Nicole Smith had been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for enjoyment of life experienced in the past and to be experienced in the future. Wherefore, plaintiffs Joseph Petito and Nicole Schmidt respectfully request the Honorable Court enter judgment in their favor and against the defendants, Christopher Laundrie and Roberta Laundrie, and award them just compensation for the damages they have suffered, together with costs and such other relief as this Honorable Court deems just and appropriate. Okay, so we're going to go, so that's the end of it. And we're going to go into um, what is intentional infliction of emotional distress and negligent infliction of emotional distress, because it seems like that's kind of what they're getting at here, basically saying that they could have done some stuff, and by doing that they could have alleviated the intense pain and suffering that they were going through during this period of time. So an important point to note, I guess, here is the fact that what they're not alleging is they're not alleging that his parents are somehow responsible for Gabby Petito's death. That's not what they're alleging. They're not alleging that somehow she could have survived through any of this by the fact that they gave, if they had given information that it would have saved her life or something like that. There's nothing like that. They're not even alleging that they had some kind of a duty or a responsibility to give information, to supply information. They haven't alleged that either. All they said was they could have and they didn't. So we'll take a look first at intentional infliction of emotional distress. Okay. So I'm just using this from the Cornell Law School website. Not every website is particularly trustworthy when we're talking about, elements of legal claims, but this one tends to be pretty good. So I'm just going to go ahead and go with this for now, just because I wanted to cobble this together pretty quickly. Okay. Intentional infliction of emotional distress. So it occurs when one acts abominably or outrageously with the intent to cause another to suffer severe emotional distress, such as issuing the threat of future harm. So there are 4 basic elements here, and this can change from state to state, by the way. So some states are a little bit, make it a little bit easier to prove IIED. Other states make it a little bit harder to prove it. But this is the basics of it, is that number one, that the defendant has done something. They've had some kind of an action. Either they've said something or they've done something. Big what? Number two, the defendant's conduct is outrageous. Number three, the defendant acts for the purposes of causing the victim emotional distress so severe that it could be expected to adversely affect mental health. And four, or D here, the defendant's conduct causes such distress. Now, when we are talking about outrageous, we are talking about something that is objectively outrageous, like something that is so outrageous that it would shock the common conscience, right? So something like uh okay, let's a really good example, I guess, that I'm just thinking off the top of my head of intentional infliction of emotional distress would be, um, if somebody were to post um, revenge illicit photos or video footage, for example. You go and you do that because you're mad at your ex, and you post that up on the internet. You do that specifically to spite this person that you are very angry at, right? So you've got an act that's posting private material, and that is illicit. Two, it's outrageous because who in the hell would do that, right? Number three, it's for the purpose of causing the victim emotional distress so severe that it would be expected to adversely affect mental health. That's like why those kind of sites exist, right? Is specifically to cause that kind of harm. And four, that it actually does cause someone harm. So, for example, like they would have to probably know that was posted up there, or something like that, and that they would have to show that they've been suffering from depression, they've maybe lost a job, or I don't know, something like that. So all kinds of ways to prove that it actually did cause emotional distress. So, but you have to be able you have to so at this point in the case, in the complaint, you have to have alleged all four of those basic elements here. So what they're saying is the act. I guess I'll pull back up. What they're saying is the act here is the it's not really an act, it's more of an omission, right? That they didn't provide information. That's what they are saying is the act. Number two, they said that the conduct is outrageous. I don't know that that's really the case, but they are at least alleging it. They are alleging that by not providing information to the public about either where Gabby Petito was or where her remains were, that is objectively outrageous. I don't, in terms of like the success of the lawsuit, I'm not convinced. I'm not convinced. I don't think that is something that is outrageous enough, because I think that is something that, any lawyer, generally speaking, gives the recommendation that if there is some kind of potential criminal liability, and people are asking you to make statements, and you're a person of interest, generally speaking, don't talk to them. Unless you are required, unless there is a you have been somehow compelled to do so. So I personally don't think that it's outrageous. However, they have alleged it. So as far as the complaint is concerned, I think that, probably so far the first two boxes are checked, even though I don't know how they're going to actually prove it. Number three, the defendant acts for the purpose of causing the victim emotional distress so severe that it could be expected to adversely affect mental health. Now, forgive me, as I was going through, I don't recall seeing an allegation that they purposely caused them emotional distress. Let me see here. Well, I guess purposeful. No, that's I take that back. Here in paragraph 30, that it says Christopher Laundrie and Roberta Laundrie knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt, and they knew that they could alleviate, at least in part, such mental suffering. Okay. And then yet they repeatedly refused to do so. So they acted with malice or great indifference to the rights. Okay. So that would satisfy this element, number three, that they acted for the purpose of causing the victim emotional distress, because if at least they knew that something was going on and they disregarded it, that in some jurisdictions can be enough for to show purpose. So number 3, as far as the allegations are concerned, the factual allegations in the complaint are concerned, I think that element 3 is met. Number 4, that the defendant's conduct caused such distress. Looking back at the complaint again, they said as a direct and proximate result of the willfulness and maliciousness of Christopher Laundrie and Roberta Laundrie, Joseph Petito, and Nicole Schmidt had been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for enjoyment of life experienced in the past and to be experienced in the future. So yes, they did allege it. Now, can they prove it? That's a whole other question. So as far as intentional infliction of emotional distress, just to reiterate, just to make it super clear for you guys, I think that this complaint does check all of the elements. So I think that it would survive if there was a motion to dismiss or a demur, depending on Florida and how, like, what term they use. It's the same thing. It's just different states sometimes use different words. But as far as overcoming that and getting into the discovery phase, I think that this would survive it. I think this would be a lawsuit at this point that would survive a motion to dismiss and would go into the discovery phase where they are exchanging they're exchanging evidence, exchanging information. So now the other possible claim that I can see here is negligent infliction of emotional distress. But before I really get into it, I caution you guys, because intentional infliction of emotional distress is one thing. That is difficult enough to prove. Negligent infliction of emotional distress is even more difficult to prove. It is exceedingly rare, to be honest. And in order to show that someone is liable for negligent infliction of emotional distress, I'll pull this back up. They have to show that the causation of severe emotional distress was through some kind of negligent action. Plaintiff suing for NIED, negligent infliction of emotional distress, must have experienced contact as a result of defendant's negligence, or at least been in the zone of danger. So what the heck does that mean, right? That is something very particular. Now, when this is alleged, usually this is going to be for a situation where, let's say, there was some kind of a massive car accident, for example. Somebody was driving drunk, and as a result of that, there was an accident, and two people, let's say two family members, were in the car. One of them passed away. The other one watched the other one pass away. You have somebody that was either experienced contact as a result of somebody's negligence. The negligence being, well, driving drunk would be more than negligence, but they could even just be driving erratically, right? They're not paying attention to what they're doing as they're driving, and they get into this horrific accident. Or you can even say that somebody's on the sidewalk, right? And they see their kid, they're right next to their kid when their kid gets hit with something, hit specifically with, a vehicle or something like that, because somebody is driving negligently. Someone who is in that zone of danger, who witnesses something happening, they could allege negligent infliction of emotional distress. Now, to me, that doesn't really seem like that fits in this situation, because you could say, okay, maybe negligence, maybe. But in order to show negligence in this case, we talked a little bit about duty earlier, right? In order to show negligence, you have to show that the defendant had a duty to do something or to not do something. And if they had a duty to do something, that they breached that duty by not doing it, being a little bit oblique in my description here, but basically that they had a duty to do something, they didn't do it, and as a result of that breach, there was harm that the plaintiff experienced, and that you can link that harm causally. You can identify a causal link between that breach and that harm. So in this case, they did talk about how the the Laundrie parents did something by not reporting. They omitted information from the public, and by doing so, that the Petito family has been suffering great emotional harm, and that they did allege the causation. But they don't allege here that there was any kind of a duty by the Laundrie family to actually provide that information. They don't allege that. All they say is that they could have and they didn't. They could have, and they knew that if they did, they would have alleviated pain, but they didn't. So in this particular case, I think that when we're talking about negligent infliction of emotional distress, I don't think that there's a case here. And I don't think that it would even survive a motion to dismiss. So basically, that just leaves us with intentional infliction of emotional distress. That's basically all that this lawsuit is really about, according to the way that this has been drafted. Now, this is a very short complaint. And normally, what I am used to seeing is something that has, a lot of subsections, and you've got a factual section, and then you've got different specific claims, et cetera, et cetera. But this is all just sort of like one long narrative of paragraphs. But it doesn't need to be broken down in that way in order for it to be a complaint that would survive. And I think that this one does actually survive for purposes of a motion to dismiss, but specifically only for intentional infliction of emotional distress. Now, then, of course, we get on to talking about whether or not this is something that would actually be successful. I'm a little bit skeptical. I'm very skeptical, because they did allege at the beginning of this complaint that the Petito parents and the Laundrie parents were on good terms. They were all talking. They were great. They were awesome. But that as soon as this whole thing sort of went down, everything unraveled. And basically what they're getting at is that as soon as Brian Laundrie murdered Gabby Petito, he then told his parents and everything changed. And they iced them out, essentially. And they could have given them information, but they didn't. So trying to show this element of intent, that they had the purpose of causing them emotional distress, I don't think it's a strong case, as much as I feel for them, because this is like, of course, like I haven't really gone into the sensitivity of this kind of a case. I understand why they would want to file a lawsuit. I absolutely do. If I were the mom in this case, I probably would. I don't know. I would look at every single avenue, probably, because I can understand that. Well, I don't know that I probably would, but I can definitely understand why they would want to pursue that, because they just lost their daughter, and nothing in the world can possibly replace it. And they probably felt very scorned by the other side. They probably really felt like they could have helped, and they didn't. And anyhow, I can understand why, and I have a lot of empathy for the situation. But looking at this as a lawyer, taking out my human brain and putting in my robot lawyer brain, this is not not a particularly strong case. And I know that there are a lot of people out there that want this to be a strong case, because of course somebody died, somebody was murdered, and it's tragic and awful, and they didn't even get to have a criminal trial, right? Because Brian Laundrie then died in whatever kind of circumstances. I don't know. Did they end up determining if it was suicide? I can't remember. But regardless, if you can't even have a trial where you can go through the the evidence and have a definitive statement in front of a jury of 12 peers and have them determine whether or not Brian Laundrie actually murdered him. I can understand why there's not much closure in this situation. Oh, I see it in the chat that it was ruled that Brian Laundrie was a suicide by gunshot. Okay. So yes, yeah, okay. So but regardless, like I understand that this is a situation that doesn't give them much closure. So I can understand why they would want to file a lawsuit like this. But unfortunately, I don't think that it's I don't think that this is a very strong case. So, what do you guys think? Maybe I will maybe I'll do a poll. Let's do this. Ooh. Okay, cool. I'm going to put this in for a minute. But all right, so we'll just do a quick poll here because I'm curious to see what people think. And yeah. So looking in some of the questions. Sorry guys, I didn't see these earlier. But there's a question, do I think that they're trying to do this to get access to Brian's notebook? That could be. I mean, because if this isn't, that's one possibility, is that the motivation for this might not necessarily be to actually get any money from them. It might just be to get access to information that maybe they have not been privy to. I'm not sure. I don't know how much of that they would be allowed to access of his personal effects, for example. But a lawsuit would definitely do it because that would be relevant information because we know that there's a diary that he wrote in where he supposedly confessed to it. So that could be one strong possibility, that it might just be in order for them to get that closure that they feel like they need. Maybe they feel like they need to see all of the information and to know what they knew on top of that. So anyhow, so there's that. Let's see if I can scroll through and find some more questions here. I'm so sorry if I missed some. Okay, so wondering if they can get texts that prove anything or depose them. So yeah, I mean it's and here's the thing about this surviving a motion to dismiss is that it like I said, it gets into the discovery phase, which means that the two sides are then able to exchange information. Hey, and civil law. Yeah, you know what? Why not? Let's I'll send you a link real quick. It might just be just like, I don't know, another like 10 or 15 minutes, but hey, let's chat about it. Sending you the link. There you go. Cool. Come on over. So in the discovery process, they are able to get all kinds of information, and it's not even information that is just like relevant to proving the causes of action, right? But it's information that could lead to evidence that could be admissible in court. So it's a very broad standard. It actually gives them the ability to look at a lot of information that they might not otherwise be able to access. So if they still have questions about stuff, this actually could be a fairly effective way of answering some of those. Hey, Kurt, how's it going?
Feel very conspicuous.
Sorry. Whew. How's it going?
5 minutes with friends is better than 5 minutes without friends. So as long
Heck
as the
yeah.
stream lasts, it's fine by me.
Yeah, absolutely. So I don't know. Did you catch the complaint at all or no?
No, I was watching a little bit of Andrew Branca because he's in my neck of the woods and just checking out his stream.
Okay.
And then I
So
saw you were still streaming. So
yeah. So basically, this comes down to they are alleging intentional infliction of emotional distress against Brian Laundrie's parents. They have alleged, and I'll go through just
how?
Yeah, right. Yeah, that's the question.
How?
It's a good question.
What is the central theory of the case?
The central theory of the case is the Laundrie parents knew on August 28th that Brian had murdered Gabby. They then hired counsel right away. And then they could have given information as to Gabby's whereabouts or the whereabouts of her remain, but chose not to. And they knew that doing so would cause great emotional harm. And it did, in fact, cause great emotional harm.
That's a fail.
Yeah.
That's a fail.
I agree.
Yeah. Intentional infliction by me not doing things that without an affirmative duty, which I don't have.
That's what I said.
It's a total. Yeah. I mean, it's nice when we come up with the exact same answer, right? It's like it's a total fail.
Yeah.
Give me another one. Give me a harder one next time.
Yeah. As I was going through. So that's why I said that this as far as meeting the requirements of a motion to dismiss, I think that this survives a motion to dismiss, but I don't think that it's going to get much further beyond that.
Well, I'm not even sure about that. How do you think it survives a motion to dismiss when your central claim doesn't make sense? Because like I didn't do a thing. I wasn't required to do a thing. End of analysis. So how do you survive a motion to dismiss?
It's just the defendant. So there's 4 elements. You have to show that the defendant did something.
Which
number 2
is a fail.
Well, an omission is an act as well.
It can be, but only if you have some sort of duty, obligation, responsibility to act, right?
No, not in this case. No, because we're not talking about negligence here. If we were talking about negligent infliction of emotional distress, yes, we would have to add in an analysis of a duty. But I think that in terms for purposes of an intentional infliction of emotional distress, I think that in whether it's an act or an omission, I think that it checks the box.
Okay, carry on.
So number 2 is the defendant's conduct is outrageous, and it has to be obviously objectively outrageous. Now, they've alleged that it is. I don't think that they can prove that it is.
Carry on.
Number 3, the defendant's act for the purpose of causing the victim emotional distress so severe that it would be expected to adversely affect mental health. So with the purpose of causing. So what they said that they did so with malice or with reckless disregard, which I think that in Florida that probably is, without doing Florida research, my guess is that they probably have a recklessness standard that survives in for the purpose element.
Oh my God. I'm just looking at the chat and now there's some it just goes my hatred of StreamYards and all these platforms. Jay Thompson says your audio sounds soft, muffled, and quiet, and I just want to commit Harry Carey.
Yours
I'm trying to do some analysis. Yeah, my audio's a little soft. Do you want me to turn it up again? So now with that, it's
I turned yours up. Don't worry, I turned yours up already. It was way low from our earlier live stream. Mine was 2 at first.
My desire to kill is increasing. What's the fact? Okay. What's the 4th factor in this analysis?
The 4th is that it caused emotional distress, which they allege, and that probably is the strongest element that they have. Of course, there's emotional distress in spades, and of course, if the defense were to fight against it, they could also fight against that element to say you already had emotional distress because of the fact.
Yeah, I mean, you can fight it all 4. For me, it's just a total fail.
Of course,
it's like
I think that's why I think
it's a fail. It's a fail through and through. It's
Yeah.
I didn't have any particular obligation to tell you that I had this information. I hired a lawyer, which I have every right to do in the world. So, like, you hired a lawyer immediately.
Hmm.
This, like, mentioning that's a total non-starter. And I did it with some sort of purpose as opposed to like protecting. No, this is a non-starter. I don't think
Yeah,
it survives a motion to dismiss. I'm throwing it
I
out.
I think it survives a motion to dismiss, but just barely. Just because
Mm.
it's such a low standard. It is such a low standard, believe me. So
But
I
it is
think
IIED, and courts do tend to look at that a bit skeptically, as I'm sure you know.
yeah, they do. They do. But I still think that this is probably enough.
Okay. Want to put a
So
fiver on it?
a fiver? What do you
Yeah.
mean?
But you
Oh,
$5.
a $5 bet?
Yeah.
$5 super chat bet?
Yeah.
Let's do it.
Okay. One
Let's
of
do
us
it.
is to admit the other one was wrong. Or right,
Sure,
as
that's
the
fine.
case may be. Fair enough.
Sounds good.
$5
Sounds good.
super
Sounds
chat
good.
on the who was
That
right
sounds
on
good.
that
Yeah,
one.
let's bet a $5 super chat on it. That
Okay.
sounds good.
All right. That sounds fine.
Yeah, but I do think so. I think that this is probably just enough to get into discovery, and I think that that's probably as I was sort of working my brain through this live, I was thinking that I think that probably is the reason why they filed it is just so that they can get access to information, so that they can get closure.
What do you think is theoretically discoverable? What do you think is the best case for discoverable stuff?
I think that something well, I mean, first off, talking to the parents, there was a whole paragraph in there about how the Laundrie parents instantly iced them out, both blocking their calls on through direct calls and by blocking them on Facebook. So, number one, being able to depose them. Number two,
I still don't have to talk to you. I have to talk to your lawyer, which is distinctly not the same thing.
well, but you still get to have questions asked of them, and they have to answer. So then
Yeah.
also,
Okay.
but I think most maybe most material is they probably want to see the journal that he wrote in, where he supposedly admitted to murdering her.
Which became their property upon his death. So
I mean, probably, yeah.
Yeah.
They would have, because he was living with them at the time, so they would
Yeah.
have that would all be in
Intestate
their
succession, right?
custody. Yeah, yeah, you could
Should we
say.
break out the table of consanguinity? I don't think we
Look,
need to do it for
basic
Paris.
basic chattel. Yeah, he and Gabby were not married, and they did not have any children, so it goes up to the parents again.
Yeah.
Very very quick intestate succession. So
Yeah. All right. Okay. So they'll get the journal. Okay, fine. Yeah, they
yeah,
can get the journal.
and probably text messages, because phone logs between the two, so that they can see when when he called them at one point. And then the question, actually, and as I'm thinking through this further, this could become something for well, I don't know. What kind of liability could the attorney be facing? I don't think so. He was just hired as an attorney, and he's definitely not obligated to give.
Conspiracy to engage in the IID because he knowingly and purposely advised his clients to withhold that information. I know that. Accessory.
No way. That's not a thing. Every single lawyer would be.
I'm well aware.
So, yeah, I mean, unless there was some sort of they didn't have any duty to give any information, because, like I said, he was a person of interest, right? He wasn't even.
I'm not 100% sure. Yeah, I don't know really how much it really gets them in the end is sort of where this all goes, because no one denies that. No one's at this point denying that he committed the murder.
Mm-hmm.
And unless the parents knew in advance, and you can get them in some sort of criminal posture because encouragement, you can get the parents for conspiracy or accessory or something before the fact. But if they only really knew after the fact or something, it's like, you probably know everything that everything says without ever looking at it. Like, you can make a pretty reasonable guess. Like, you just use your worst case scenario and you're already there. Okay. It's like, yeah, okay. So the journal says everything you think it says. The text messages say everything you think it says, these back and forth. And in light of those text messages, The parents clammed up, hired lawyers, disconnected because obviously they didn't want to say anything because their
Yeah.
lawyer told them to shut the hell up, as
Yeah.
you or I probably would tell them, shut the
Right.
hell up.
Right.
Should I take this call from this person? That sounds like a fucking bad idea. Don't do that.
Yeah.
As if I'm their attorney.
Yeah.
So let's not do that plan. So it's like, I just don't know what you're really getting out of it. It'll just confirm everything you think is already true anyway. So what's
Which
the point?
maybe that's what they need. Maybe that's because what I was saying before you came on is that there wasn't even a criminal trial in this case for a pretty horrific murder of their daughter.
Well, it's
and
a little hard
so
to prosecute.
Oh, well, of course, and I'm not blaming anyone for that, because that's, I mean, the prime suspect offed himself.
The prime
So
suspect being dead does somewhat preclude a criminal trial.
of course it does. So, but then you don't get to have a jury of your peers determine that your daughter was murdered by someone. And I can understand why that just it would be so hard to move from, because you don't necessarily get closure, I think.
I mean, I couldn't say what I would do in that situation if I were the parent. Although me being a lawyer and defense minded, I probably would be more inclined to go along the same ones as Laundrie's parents, I would think. I mean, I wouldn't know. I mean, if it were your kid and they came to you and said, "Hey, by the way, Mom, just off my girlfriend over here, I just want to let you know about that." How do you think you go about that? Do you tell the other parents?
Shut the F up.
Do you tell the other parents about it? Do you tell the other parents that I know about that your daughter's dad? Do you?
No.
Yeah.
Because then of course, if you then go and say, "Oh, this is where I think your daughter where she is, where her remains are," how the hell are you going to find that information? It's pretty quick. People realize pretty quickly where you got that, right? Like, you weren't there. You were on the opposite side of the country.
That's where I tell my kid to pay me $1 so that he can hire me as his lawyer, so that he'll have privilege.
Yeah.
Yeah, that's good times.
Yeah. Yeah. So the results of the poll, I asked, do you think the Petito parents have a good case for intentional infliction of emotional distress? 61% said no.
Not a chance in this world.
38% said yes.
No, not a chance in this world.
Yeah, I don't think so.
Intentional infliction, the key word is intent. I intend to inflict. It is I am trying to inflict. And you're more than anyone can bear. And I can't think of, I mean, I'm going back in my mind to law school, but I can't remember any IIED cases from lack of action. Can you? It was the IIED case was always, you go up to a woman with a child, for a fact her child isn't dead. You tell her child is dead. That's IIED.
I don't know. See, I could see a situation like, let's say, I'm just pulling this off my head, but like, let's say you're mad at somebody and that they require, what's that?
I'm mad at StreamYards. Does that count?
Okay. Let's say an individual.
Okay.
Let's say that there is an individual that in your life that requires insulin shots, and they are unable to get those inject those shots for some reason, and you are the only one that can do it, and you decide, I'm so freaking pissed at this person, I'm gonna not do it.
If I don't have a duty, I mean, if I don't have a duty, I can literally watch you drown in a lake and do nothing.
Let's say you
as you're slowly going below the waves of the water, Legalbytes, I can sit there eating my popcorn.
Well, that's true. Yeah, I know. I'm trying to think of some hypothetical situations with omission and where that's successful. I still think that it's enough to allege it, because you could at least try to make an argument for it.
Okay. Well,
I don't think it's going to be successful.
No.
Anyhow. So yeah. So that's that. Well, that's all I wanted to go over with this. It's a very short complaint, so I just wanted to go over it super quick.
A very short complaint with a very short dearth of facts. Annoying. Yeah. When I did that on my channel recently, because someone on Twitter was asking me about this big YouTube channel trying to take down the small YouTube channel, and sued him for copyright infringement, of DMCA complaints. We got the entire channel taken down and sued him for copyright infringement. And the thing is so bare bones. I'm like invoking Rule 12E for a more specific complaint. Because like I don't know what to do with this. I literally I can't analyze this. There's nothing for me here.
Oh no.
I was like, well, this is going to be a really short discussion because there's no, all they say is you downloaded our work, made derivative copies and uploaded. I'm like, what am I supposed to do with this? I got nothing. Like, I need more. Give me more information so I can make an analysis over here, damn it. But they don't want to accommodate me, Legalbytes.
They don't. They don't. And that's the thing is that like sometimes a plaintiff's lawyer can, there are two ways that you can kind of strategize it. Number one, you can say, I know I'm going to allege just enough and then make things difficult for the defendant. Like they can kind of figure out what it is that I'm suing them for. I've never been that kind of lawyer. For me, I've always like been on the opposite end of that spectrum. Like I'm going to make it super clear exactly where these facts fit into, and I'm going to lay out all the elements of each claim, and then go into like full on IRAC for each issue rule analysis conclusion for each charge, because that way you never get a motion to dismiss. And so or the crack conclusion CRAC, guys.
Yeah.
So, but that way,
this is dumb. Here's my analysis to prove my point.
Exactly. But that way, your client never has to pay for fees for extra time for you to fight over a motion to dismiss.
Fair enough. I know you've been streaming for a while, but I just got here. I want to talk about something. I just don't know what that is. I got nothing else to talk about, damn it. I want to talk about something else. What's going on, Johnny Depp?
Nothing new at the moment. But there will be, I'm sure. There's actually today. I thought it was going to be next week that Amber Heard's lawyers had a deadline to respond to the motion for summary judgment that I just went over the other day, but apparently it's today. So hopefully there will be a filing that will be visible on the court docket system.
And I also don't know the answer to this question because there was that whole Brad Pitt thing with the winery, was it?
Mm-hmm.
Yeah, has that actually been filed? Is there a filing on that?
Yeah, that was filed back in February.
Oh, have you discussed that in depth?
Yes, last week.
Okay. Yeah. I should catch up on that one though. Try to figure out what's going on there.
Yeah, it's interesting. It is interesting. So.
All right. Well, anyone in the chat want us to discuss anything? Just unbreaded. I could read a chapter of the unbreaded.
All right. Well, I probably should get to bed because it is very late for me.
Well, that's right. I keep forgetting your time zones.
Yeah, I know. It's unfortunate. It won't always be this way, but for now I've got to have a somewhat healthy sleep schedule.
Yeah, you're very healthy, and thanks for sending me your workout. I'll send you my workout today.
Yay. Sounds good.
All right. I'm going to let you guys go.
All righty.
I'll stream on my channel about something.
All righty. I will see you. Thank you to Kurt, to Uncivil Law, for joining me. Thank you to everybody in the chat. Yeah, this has been great. Okay. See you guys.
Bye.